think of some sprawling, some large mansion somewhere. So I don't need to plan for an estate because I don't even have it. But I want to break down some of the myths regarding an estate plan. An estate plan is simply the process of making it clearly known how you want your estate to be handled after you pass away, or if you are incapacitated. Okay, so it's how do you want your business, your money, your healthcare decisions, all of those things to be handled in the event that you pass away. And I like to say estate planning does three things. Number one, I like to say that an estate plan, first of all, it protects your grind, it protects your hustle, it protects how you make money. And we don't have to wait till we pass away to protect those things. We want to protect those things right now while we are alive. So that's what it protects. Number two, it protects your health. In the event of a medical emergency, we want to make sure that people we love and trust are legally empowered to make very important decisions on our behalf so that we experience a quick and speedy recovery and that we bounce back. The last thing we want to do is have someone who we don't trust or who we would not have wanted being the main point person advocating for our healthcare or our very important healthcare decisions in the midst of crisis. And then last but not least, an estate plan determines who gets what when we pass away, so that it is part of it, but there are components of an estate plan that do protect us right now while we are alive. And I'll go back to share. So simply put, an estate plan protects yourself, your loved ones, and everything that you've worked so hard to acquire. So let's talk about what happens if you pass away without an estate plan. I don't know, has anyone here had to manage the affairs for someone close to them, like a mother or father who's passed away without an estate plan? Okay, Ms. Bradford, I see you. So tell me a little bit about that. What happened when you had to manage those things?
Well, it was a lot, in the process of grieving, thinking that, okay, this stuff is probably together. It was just overwhelming. Like, I didn't know where to start, what to do. I didn't know that, there should be a beneficiary on bank accounts. My dad, I couldn't get into his account until we got the death certificate. That was taking a long time. So it was just a lot, things I just didn't know, which once I learned, making sure your beneficiaries are up to par, making sure you're not just an authorized user on bank accounts, but that you have an actual beneficiary identified, and just going through the whole process of, life insurance, what assets he had, because he did not have a will. It was intestate,
Yeah.
right? And so we had to wait for all the dead people to stake their claim on what he had and all that kind of stuff. So that was just what I can remember.
Yeah, it is a lot. So when someone passes away without an estate plan, that's called intestate. And that person's estate has to go through the probate process. And so I know I made the joke before saying estate, I don't have an estate to plan for, so I don't need an estate plan. That was kind of my own mentality. But estate basically just means all of your belongings. Whatever it is that you own, that's your estate. It doesn't have to be $1 million estate. It's just whatever you've owned, you've inherited, all of that makes up your estate. And so when someone passes away, you have to go through the process of probating their estate. And this is a legal procedure that your estate goes through. And during this legal proceeding, a court will start the process of distributing your estate to your heirs. But before your heirs get anything, all of your taxes, debts, and expenses must be paid first. And the key things to understand is just because you don't create an estate plan doesn't mean there is no plan. What it means is you're going to do the state's plan. You're going to do the state of North Carolina. They have a plan. Every state has a plan for what happens to someone who passes away without a plan, for someone who passes away intestate. And you may not agree with that plan, okay? if your spouse passes away, for example, and you don't have children, then your spouse's estate is split between the spouse and their parents. And some of you may be fine with that, and some of you may not be fine with that. So it's very important that you create a plan for how your assets are to be distributed, because you may not agree with the plan the state has for you or for your spouse. You go through this probate proceeding, and it's, as Ms. Bradford said, you will be grieving, you will be exhausted, and now you have to pay court costs, court fees, do applications, go through all of their expenses, publish that they've passed away, resolve any debts that they have. If I pass away and I have a $5,000 Target credit card, that $5,000 that I owe doesn't just disappear. So it still has to be paid. And Target is watching for when people pass away who owe them money so that they can file their claim with the courthouse to get their money back. So before your family gets anything, all of your expenses have to be resolved. So that's first and foremost through the probate process. The other thing to consider is that this process is public. So all of the debts, all of the expenses, all of the taxes, all of this will be published. It's court record. You can look up anybody who's passed away. And I have some clients who don't care. You know, they say, I'm going to be dead. I don't care if my process is public. That is the least of my concerns. And I totally support that. My job is just to make sure that people are informed and empowered about it so that they can make decisions that are most in line with their wishes. So to be clear, if you pass away intestate, your family will have to probate your estate. If your parents pass away intestate, you will be responsible for probating their estate, which can take a year to 2 years, depending on how diligent you are in this process. And a lot of times I get calls from people who started the probate process, are intimidated by the probate process. And at this point, they just want to hire a lawyer to do that. And if I'm being quite honest, it's more expensive to hire an attorney to come in at the end to probate the estate than it is to create the estate plan and then just have them manage the things after the person has passed away. Okay, so I've shared, let me go back to sharing my screen. I've shared about the probate process. I've shared about when a person has no plan, they've passed away intestate, and I want to talk a little bit about what a will is. If you look at this slide, I have some common components of a comprehensive estate plan, and I'm going to talk to you all about it just briefly. This is estate planning 101, so I don't want to get too deep, but I do want you to feel empowered knowing more about estate planning than what you did 10 minutes ago. So in a comprehensive estate plan, no two plans are alike. And I'm not the attorney who suggests that everybody must have a trust. That's not me. A trust is appropriate for some people, but it's not appropriate for everybody. So let's start with a will. What is a will? A will is a legally binding document that indicates how you want your estate, your worldly possessions passed on at the time of your death. If you would like to draft your own will in North Carolina, it's pretty simple. First, you're going to declare who you are, you're going to declare where you live, and you're going to declare that you are of sound mind, that you have testamentary capacity, meaning that you understand the decisions that I'm making will distribute my assets at the time that I pass away. So you'll write some statement that says I'm of sound mind and I understand that this document is legally binding. After you do that, you will declare who your beneficiaries are, meaning if you're married, you're going to indicate that you're married or that you're unmarried, and then you're going to list who your children are, which those are your beneficiaries. If you don't have any children, you're going to indicate who you would like your beneficiaries to be, your spouse, your nieces, your nephews, your goddaughter, your godson. You're going to put somebody there or a charity, because if you put nobody there, those assets may eventually end up belonging to the state through a process that's called an escheat. So you're going to put who you are, where you live, that you have testamentary capacity, who your beneficiaries are, and then you're going to indicate how you want your assets distributed. you're either going to do shares of your estate or you're going to list out specific things that people are going to inherit. Last but not least, you're going to appoint an executor. This is the person who you name to manage your affairs. So after you pass away, to pay your taxes, to pay your debts, you're going to appoint somebody you trust, and you might even appoint a backup executor, because sometimes life happens and our executor passes away before we do. And then in order for the will to be valid in the state of North Carolina, you must sign and date it. And then you must have 2 witnesses to also sign and date your will. And those 2 witnesses cannot be people who are a part of your will. They are 2 neutral parties who are signing, saying that, yes, she seemed like she was in her right mind when she did this, right? So they're going to sign and they're going to date it. So that is what your will does. What's important to understand is if you are a parent and you have minor children, your will is also the document that's going to appoint the guardians who should take care of your children should something happen to you. This is very important. If you do not appoint guardians to take care of your children, God forbid something happened to you, they will most likely end up in foster care. Even if your mama or your sister or your brother or somebody would take your children, that might still happen while they're sorting everything out until a judge can legally appoint that person as the guardian. And if the child has lost their mother or father, the last thing you want to happen is for them to maybe experience additional trauma by sleeping by a stranger. And that's not to say there are not amazing foster care families, but if you already know that you would have somebody take care of your child, then as parents, we're obligated to go ahead and take that next step to formalize that to kind of prevent further injury to our child. So that is a will. Are there any questions about wills? Yeah. Okay. So
yes, I have a question.
Okay.
How you doing? My name is Tracy Hester.
Hi, Tracy.
Hi. I had two. It's a two-part quick question. Can you explain what a holographic will is?
That is when somebody's like reading their will on a video. Is that what you're referring to?
Well, I think from what I was told, it's like literally just writing, kind of similar to what you said, writing stuff out and filing it with the court, with the I guess going downtown to the court and the clerk of court and getting it stamped.
Okay. So Tracy, I'm to be honest, I don't use the term holographic will. I know that there are all types of different references to a will, but the will I'm referring to is a traditional will, a last will and testament, your final declaration and decree. There's video wills, there are holographic wills, but all you need to know is for your will to be valid in North Carolina, you have to have those components that I said. In addition, you have to sign and date it, and you have to have 2 witnesses also sign and date it. People think that they can just write a paragraph and they can just say that this is what I want to happen, and they don't have those 2 witnesses, and that will is not valid in the state of North Carolina. So if you're referring to a written will, when you say holographic will, as long as it has those components, that's what makes it valid in the state of North Carolina. But every state has different requirements for what makes a will valid. I hope that answered your question. Because when I go and Google, it just says a written will. So if that's what you're talking about, that's the same thing that I'm referring to.
Okay.
But if you go to the clerk of court and say, I want to file a holographic will, they might blink a little bit. Just say I'm filing my last will and testament. They might have a little stutter step like I did, like, okay, because that's not typically how we speak or refer to it, but just a written will, as long as it has those components, then you're fine.
Okay. And my other question was regarding like the kids, right? So what if you had, like, I have an older child and I have 2 younger ones, but I'm also married. And okay, it's kind of a little bit complicated. So my husband is not the kid's biological father, but I have custody over our kids, which is my ex and I, right? So if something was to happen to me, can I give my oldest, is there a way to write it where my oldest will have custody of them?
Yeah. Yes, there is.
Okay. All right.
Yeah, there is. There's a way that you can do that. There's one, or they can have it together. There's a lot of options that you can explore. Of course, a judge is going to be the one to have the final say, but you are guiding the judge in making that decision by putting who you're appointing in your will as the guardians for your children.
So why would the judge have the final say on that if the oldest child is like over 18 and I'm specifically directing, like, that's the custody? Like, why would the judge have that say? Like,
well, the judge has the final say because you passed away and you are the biological mom. So if you are going to appoint someone in order for the oldest child to enroll them in school, to take them to the doctor, to do the day-to-day tasks and activities, they're going to need a document that says, I am now the legal guardian to do that. And that comes from the judge.
okay, but it's not a situation where the judge could say, no, we're not going to give the oldest child custody, even though it's
I don't want to get too far. There are situations where that might happen. I don't want to scare you, but more than likely, as long as your oldest child is stable, not using substances, has a place to live, reliable transportation, the goal of the court when they act as the parent, which is the legal term, and they're acting on behalf of the parent, is to keep a family together. So I don't want to scare you and make you think that they would not follow your wishes, but I don't want to say 100% of the time they follow the wishes, because there might be something that comes up that says, oh no, this may not be a good fit. But as parents, that's why we're going to nominate guardians. And not only are we going to nominate a first choice, but we're going to nominate a second choice and a third choice. So should something happen with the first choice, we've already listed the backup and then the follow-up. So there's no question, we've provided who will take care of our children.
Okay. And in that instance, can, like, if you have custody over the kid, can if the biological parent is still living, can they come and contest that?
Again, that sounds like we need to have a consultation, Tracy.
Okay. Well,
because that's all very nuanced, and I don't want someone to say, well, Attorney Perry said, if I appoint this person, this is definitely going to happen. And the legal answer is it all depends. But what I will say is, for when I have clients who have blended families or unique situations, there are things that I do in my guardianship package, including a confidential letter of exclusion, which is a letter of why I have, even though this person may be a great choice. Let's say you have a brother, right? And on paper, he looks amazing. He's been married for a long time. They make a lot of money. But you know that in their home, there's domestic violence or substance abuse or something along those lines. And so while your brother might be the perfect fit, you would never pick him to raise your children. So we write a confidential letter of exclusion. We write it, we explain everything, we make it a part of your packet, and it stays private unless your brother goes to the courthouse and says, I want custody of these children. Then we present this letter to the judge and say, oh no, mom thought about this, and this is the specific reason why she does not want brother or biological father or whoever to have custody of their children. They've been convicted of this. They've done this. Here's the public records. And this is why mom is excluding this person as a guardian. And then that's something that you can make as part of your comprehensive estate plan.
Okay.
Thank you, question?
Tracy. Oh.
Yes.
Thank you, Tracy. Siobhan, we have a question in the chat, and the question is, what if one of the witnesses is now deceased?
Oh, as long as they signed and dated at the time that the will was done, then that should not be a major issue. Yeah, because what the witness is saying is, at the time the will was created, the person who created it had a sound mind, they had testamentary capacity, and they knew what they were doing right at that time. So witnesses don't live forever. the people who write the wills don't live forever. As long as there's a valid signature from a neutral party, signed and dated, then you should be fine. If you want to take the extra step like I do with my clients, I also have the will notarized.
And if you could, if you would go back and tell what the required elements would be if someone, wanted to draw up their own will. We had some other people join, and I wanted to just make sure we covered that before we moved on.
Yeah, sure. So you're going to list who you are, where you live, that you have testamentary capacity. You're going to list who your beneficiaries are, how you're distributing your assets into shares or percentages or specific items. You're also going to list, if you have minor children, who the guardians should be of the minor children. You want to include the executors, who's going to handle the estate after you pass away, a first choice and a second choice. You want to have a statement that you have testamentary capacity. You're going to sign and date it. And then you also want to include 2 witnesses who witness you signing and dating it. And they will also sign, print their names and date. And then if you're feeling fancy, also have a notary present or a mobile notary present at the time. And to the question of the holographic will, which is if you're going to write it out, you include all that. You're just going to do that by hand.
Okay, thank you. Did anyone else have any questions about wills? And we will also put up Attorney Perry's information for consultation, and she'll tell you how that goes, but we'll put all that information up at the end.
Yes. Okay. So the next document I'm going to talk about is your Advanced Healthcare Directive, which in North Carolina is also known as a living will. This is a document that indicates how you want to be treated with respect to decisions, end of life decisions, terminal illness decisions, vegetative state decisions, how you want to be nourished or hydrated or life support. So that's the living will or Advanced Healthcare Directive. In addition, comprehensive estate plans includes power of attorney documents. That could be a healthcare power of attorney document, or it can be a durable power of attorney document or a limited power of attorney document. A power of attorney document simply means that you are giving someone else the power to make important decisions on your behalf. So when you do a durable power of attorney, you are giving someone the authority to access your bank accounts, to sell your home, to purchase a home, to manage your digital assets, your social media, your digital wallet, your cryptocurrency, your insurance policies, your other assets, your land, only while you are alive. The reason why you would want to do something like this is because should you experience a medical emergency, should you travel out of the country, should you be somewhere and you need someone else to manage these important decisions on your behalf, you want to make sure that you've appointed someone that you trust to make those decisions for you. Some of the more tragic stories that I've heard is an incident, an accident, an injury. Someone is now in the hospital recovering and they've lost everything they had because no one was empowered to speak to their mortgage company for them, to keep their apartment, to keep them from losing their apartment or foreclosure on their home. And so now when they've recovered, they don't have anything to come back to. And they have some of those challenges or complications associated with their recovery. Now they're in financial ruin. Your healthcare power of attorney allows you to appoint someone of your choosing to make important healthcare decisions for you in the event that you cannot. This helps to reduce conflict in the home. Sometimes you might have a situation where multiple siblings are fighting for who should make the decision for mom and dad or for brother and sister, and the person making decisions may not make decisions that's consistent with the person who needs the treatment or the recovery. So it's important that you nominate someone of your choosing for your healthcare power of attorney. And limited powers of attorney is when you give somebody the power to do something limited, to sell your car, to manage a specific asset, to make specific decisions. So that's the power of attorney documents. Are there any questions about power of attorney documents? No? Okay. I spoke about probate already, so I won't go back into that. And then last but not least, I'll talk about trust. The trust that's the most common is a living revocable trust. When you create a trust, there's typically 3 roles. You have your grantor, you have the trustee, and you have the beneficiary. The grantor is the person who is creating the trust. So while you are alive, you will be the grantor. You are the person who creates the trust. So I just realized that I did not share my will screen with you, but I pretty much talked about it. Before I go into the trust a little more, I did not mention that wills go through the public probate process, okay? So wills go through the probate process. Just because you have a will does not mean you avoid probate, but instead of this court and the state telling you how your assets will be divided, you are telling the state, this is how I want my assets to be divided. So I'm just rewinding for a second.
I'm sorry, since you rewinded, we had another question in the chat. Should we file with the clerk of court for the will to be valid?
As long as the will is signed by the 2 witnesses, dated and signed by you and has those components, it's valid. Signing with the clerk of court is just making sure that the court has a copy of the will on file before you pass away. So that's a personal preference if you want to file it or you don't want to file it. A lot of people like the peace of mind of knowing that my will is filed with the clerk of court and that they have a copy of it. And if anything happens, it's already filed. Some people don't want to file it with the clerk of court because they're like, I don't know, I might make changes to it. And I don't want all these different versions of my will in public record where they see that first they were getting 50% and now they're getting 25%. So it's personal preference. But filing it is not what makes your will valid.
Thank you.
Okay, you're welcome. Okay, so wills do go through the probate process, but unlike passing away intestate, intestate means the state is dictating how your assets are distributed. When you have a will, you are telling the court how you want your assets distributed. Okay, now trust. So like I was saying, trusts have 3 parties, the grantor. When you are alive, you are the grantor. You are the one who's granting or creating the trust. The trustee is the person who manages the trust, who manages all the assets in the trust. While you are alive, you are the trustee. And the beneficiary is the person who's benefiting from the trust. And while you are alive, you are the beneficiary. So while you're alive, you are all of them. You are the grantor, you are the beneficiary, and you are the trustee. You're creating the trust, you're managing the trust as the trustee, and you're the beneficiary. You're the one who's benefiting from having the trust. Some of the benefits of having a trust is a trust may avoid probate if your assets are in the trust. So when you are the grantor, you create this trust. It's a legally binding document that says, I'm creating this entity to hold my assets. We're all walking around holding a lot of assets. We may own homes, we may own cars, we may own land, we may own life insurance policies, retirement policies. We also have debt, expenses, and businesses that we may or may not be managing. What happens sometimes is when people pass away, all of those things spill everywhere. And when those things spill everywhere, Pam, like you were saying, did you know all of the bank accounts that your father had? Can you share some of that? Or was it your mother or your father?
It was my father.
So did you know all the assets that he had?
I mean, after going through a lot of paper. Yeah, it wasn't like it was in one place. You know, we had to go through the whole house to gather all the information to find out, you know, whether he owned it or if it was still had a lien on it or debt associated with it. Yeah, it was everywhere.
Yeah, so That's kind of how we all are. And when we pass away, our family is trying to figure all of this out. You know, what bank accounts did they have? Where did they own money? Where are all their assets? When you create a trust, the goal is to centralize all of those assets into one place. So when you pass away, when you transition, or when your loved one transitions, they're not scrambling all over the place trying to figure out, are they missing an asset? Because if they miss an asset, it's going to go to the state Department of Unclaimed Assets, and you can check there your name, your loved one's name, somebody who's passed away close to you, and see if the state is holding some money for them, because they only hold it for a certain period of time before they take the asset for themselves. So you definitely want to check North Carolina's Department of Unclaimed Assets. So anyway, when we talk about a trust, that's the central place that's holding the assets. So when you pass away, they're not spilling all over the place. They're all contained in the trust. So you create your trust as the grantor. And when you create your trust, you put your home in the trust. I have a little letter H. You put the beneficiary of your life insurance policies in the trust, right? You put the beneficiary of your retirement plans in the trust. You put the beneficiary of your savings or stock accounts or whatever. I mean, you make your stock accounts in the name of the trust. So now when something happens to you, you're handing somebody a nice, neat box of assets instead of assets all over the place, and they're looking for bank statements, and they're trying to hack into your email account, and they're trying to figure out what you have or what you don't have. You're handing somebody a nice, neat box. And since you are the grantor, you can take assets in and out of the trust as you see fit, because you created this trust. So the other benefit of the trust is it may be private. If the trust owns the assets, those assets don't have to go through probate. They can just immediately be passed on to the next person without all of the hoopla and expense of probate. And then additional benefit of the trust is it may offer your beneficiaries, asset protection. And what I mean by that is, if you leave a lump sum of money to a beneficiary, right? Whether that's through a cash distribution from an account or maybe a life insurance policy, that money can be vulnerable. Who knows what I mean when I say that money could be vulnerable? What do you guys think?
Meaning like debt that the deceased may have acquired that has to, all the debt, they will use that money to pay the debt, maybe?
Close. Now, money that somebody receives through a beneficiary, such as a life insurance policy, does not have to go through probate. So that is the benefit of having a life insurance policy. But the person who receives that money may have debt, and you may not have wanted that money to go towards their divorce settlement. You may not have wanted that money to go towards the payment of a car accident. So let's say, hypothetically, somebody we know has passed away and they left us $100. Whether that was $100 cash or $100 as a beneficiary or $100 in some way. If I the next day get into a car accident and I hurt somebody, right? That money that I have, that person can sue me for that $100 now. They know that I have it. They can sue me for it. That money is vulnerable. If I have a tax situation and $100 hits my bank account, that money could be used for that tax situation. Let's say if I'm going through a divorce settlement with my spouse or with a loved one and they want alimony, part of what the court will consider is some of the assets that I have, and that $100 I inherited will now be considered. That money is not protected. That money does not have asset protection. So that's something that you can add onto your trust that you could not do through a will. So meaning if I have a will and I give somebody a cash payout from an account, that money is vulnerable to lawsuits, it's vulnerable to divorce settlement, it's vulnerable and that I could have a judgment or a claim against it. Does that make sense? That's different. So it's not vulnerable to the person who passed away, to their claims, But me as a person is vulnerable to the decisions that I might make in life. Does that make sense?
Yes.
So that's just something to consider. So for example, I have a story where someone received a lot of money from an uncle who passed away. They went to visit a friend. And when they visited the friend, they were going to draw themselves a bath. They left the water running. They went to open the door because another friend came over, and that water was just running and running and running. It soaked through that person's condo and dripped through the person's condo after them and kept dripping through all the apartments. And yes, insurance covered a lot of it, but now they were liable for some of those damages. And that is an example of how that money that they inherited all of a sudden became very vulnerable. So one of the benefits of having a trust is knowing that you can put asset protection features in that money.
Somebody's unmuted. If I could just ask everybody to check to make sure that you're muted. Thank you. I know it's easy to come off. Siobhan, I have a couple of questions. So, and I know you were in mid-thought, but let me just ask these questions. So the question is, does the pour over will put assets you forgot to move into the trust?
Yes.
Yes. Can you explain what the pour over will is?
A pour over will can be a couple of things. A pour over will says any assets that I did not put in the trust, I want it to go into the trust. So I created a trust, and before I died, I purchased a second home and I didn't have a chance to transfer it into the trust. The pour over will indicate that that asset should now go into the trust.
Okay, now I have a question. How does one put things in the trust?
Yeah, so when you're putting your home into the trust, you're just going to deed it from yourself into the trust. If you are making the trust the beneficiary of a retirement policy or a life insurance policy, you just change your beneficiary designations through whatever forms that are for your retirement company or your life insurance company. With the bank account, you'll go to a bank and you'll say, I want to create a trust account for my bank. I want to create a trust account with this bank. And you can use that bank account as you normally would any other bank account. It's just now owned through your trust. So right now, your home might be in the name of, I'll just use you, Miss Bradford. Your home might say, Pam Bradford owns 123 Sesame Place. What you'll do is you'll draft, or you'll ask an attorney to draft a new deed that will say Pam Bradford is transferring her home 123 Sesame Place now to Pam Bradford, trustee of the Sesame Family Trust, right? So now you're managing the home as the trustee, but the trust owns it. And so that's how you would transfer the home into the trust.
Awesome. Okay, thank you. Does anybody else have any questions about trust?
I do. I'm sorry.
It's okay. Go ahead.
Right. So if you put a home in a trust, and the trust is pretty much you're managing the trust, right? How does that affect, like, with taxes? Like, does that impact the taxes any?
It shouldn't. It should not affect your taxes because you have not sold the home, right? You're just changing the ownership from yourself to yourself as a trustee. So it should not affect your taxes of your home now.
And if you're still paying on the home, can you put the home in the trust?
Yes. Yes, you can. This is a common thing, and you can take it out if you want to sell it, if you want to get a new loan or equity line or refinance it, and you can put it back in. That's the benefit of the revocable trust, because that means you can make changes to it. You can take things in and out. So that this is a very flexible estate planning option for most families. And the benefit is, when you're transferring the asset, since the trust owns it, it can be deeded to the new beneficiary right away. You don't have to wait for a judge to do this through a probate process, because the trust is an entity that is not dying. The trust owns the home. The trust owns the land. The trust owns the real estate. And so just to clarify some of the differences between a will and a trust, the will goes into effect after you die, but the trust is something that's with you while you are alive and when you pass away. A will cannot offer asset protection, but a trust can offer asset protection. A trust can put strings on your money. For example, a will just give a payout to your niece or your nephew or your son or your daughter. And I don't want to devalue a will. A will is a very important document. If, for example, if you are not a homeowner, if you don't have minor children, a will is probably an estate planning tool that is perfect for you. You are somebody who may not need a trust. But if a will is giving a lump sum of money to a person, that's all it can do. Whereas a trust can say, I'm giving you a portion of the money at 18, a portion of the money at 25, and another portion of the money at 30. Or I'm giving you the money when you graduate college, or I'm giving you the money to pay for a wedding. A will cannot hold money for an event. A will can just disperse the percentage you're entitled to, whereas the trust can hold money until a specific age or until a specific event. So that's why it's a wealth planning tool that a lot of families like, because they may not want an 18-year-old to inherit money. And the other consideration is if you pass away and leave a minor child behind and leave them a large sum of money, a judge is just going to create a trust for them anyway. A judge is not going to give your child $200,000. And the judge is going to hire a lawyer appointed by the court to draft a trust anyway. So guess who's going to be paying for a trust anyway? Your estate will be paying for a trust anyway. And not only that, who will the trustee be? The judge will appoint a lawyer to be the trustee. So they're going to be billing your estate until your child turns 18 or 21 to manage it for the 5 to 7 to 10 years anyway. So that's why I say if you don't have minor children, a will is a great planning option. But if you have minor children, a trust would be created for you anyway. So you might as well be the one to create it with the rules and stipulations that you want for your minor children. A will cannot control the assets after death. Just like I was saying, a trust can control how your assets are managed after you die. A will requires the probate process. A trust may avoid the probate process. A will is a public document and a trust is a private document. Are there any more questions about a trust or how it works? Are there any more questions or concerns about that?
So yes, there we have one other question. We have a question in chat, and then I have a question.
Okay.
Question in the chat is the trust protected from the IRS?
What do you mean protected by the IRS?
Tracy? I'm thinking if you owe taxes and...
if you owe taxes, then you owe taxes. I mean, the IRS is going to get their money. So a trust is not a tool that you can use to evade taxes, despite what all of the social media gurus are telling you. If you owe money, then you owe money. What a trust can do is reduce the taxes that you have to pay depending on how the trust is structured. For example, if your home is owned by the trust and then your children inherit the home from the trust, they will not have to pay the capital gains tax on that home. As opposed to if you just add them to the deed, they will be responsible. Mom and dad bought that home in 2010 for $250,000 and now it's worth $600,000. They're going to have to pay taxes on that come up in price. Without a trust. With a trust, they can avoid the capital gains tax. There's also some tax management strategies with a trust. For example, estate taxes federally is if you pass away with an estate over like $6-point-something million. Don't get me to quote the exact amount because that changes with each administration. But if you are a couple, you can split up the assets into two separate trusts so that each person is under the taxable estate tax requirement. so that it falls under that 6 point something million. So there are tax planning strategies that you can use with a trust, but if you owe taxes, then you owe taxes, and you owe them. So I hope that answers your question.
Tracy, did it answer your question? Yes, it answered.
Yes,
I think.
yes. All right, something's going on with the microphone. Sorry about that. Yes, I think I just was under, because I've spoken to a couple other attorneys in the past, and I was under the impression that your trust is something where like the IRS cannot like take your assets out of the trust, irregardless of if you owed something or not. So I didn't know what they were directly speaking on as it pertained to that.
Would that be an irrevocable trust?
If you owe money, you owe money. That's what I'm gonna say. With the IRS, if you already owe that money, you owe that money. Now, if you irrevocable trust planning strategies are again are strategies that people use, extremely wealthy people use to reduce their tax liability. But if you already owe money, then you already owe the money. So maybe that's what they were referring to, reducing their tax liability strategies. The issues with irrevocable trusts is they are very expensive to manage over time. Some people have offshore irrevocable trusts. So that is also something to consider. Irrevocable trusts are also a planning tool that people use for Medicaid planning to transfer their homes and their assets into that, because they have to be transferred for, I believe, 7 years, but don't quote me on that because I don't do Medicaid planning, but that's also consideration for that. Or is it 5 years now? I'm not sure.
Mm-hmm.
Yeah, so those are some of the strategies that people use with irrevocable trust, but they offer much less flexibility. You can't take assets in and out of them in the same way that you can with a revocable trust.
Okay, thank you.
And so thank you, Tracy. My question was, can you put your business, because this is another thing that they have on TikTok. Are you able to put your business in your trust or in a trust? Okay.
Yes.
Similar to the house. You just Okay.
Mm-hmm.
Okay. Yes. Any more questions? Anybody else have any questions?
But so if you already owe the IRS something, just putting it in a trust doesn't change that you owe them something. But if it's pre-owing taxes, before you owe any taxes, right? And you're doing tax planning to avoid, you're doing tax planning strategies with your tax professional, then a trust can be a tool that you use to manage future expenses and liabilities. But if you already owe something, then you owe something. They're gonna get their money. I hope that clarifies.
Mm-hmm. It's clear. Yeah, I think so. Okay, yeah. You can keep going.
So this is kind of a roadmap as to what it's like working with me. Typically, I offer free consultations for clients. If you're interested in estate planning, or you're interested in your mother or your father talking about working with me for estate planning, most of my stuff is done virtual through Zoom forms, and through Zoom meetings and a client portal where we exchange forms and important information. There's typically 2 to 3 Zoom meetings, and then in person, we meet for our signing meeting. And that's where your documents get signed, notarized, witnessed, and they are completed. And to work with me, your timeline is about 30 to 45 days. I have some clients who complete it faster and some clients who complete it slower, but that's just kind of a sense of what it's like to work with me. And then here is my email address, savon@easerlegal.com. And this is my office phone number. And I don't think anybody should mail anything to me. These days, you can just email me. And my website is easerlegal.com. And does anyone have any questions? Yes, no?
Going once. Y'all trying to think of your questions? Going twice?
I'm trying to think of mine. Sorry.
All right. Well, I want to say, is everybody been able to take a screenshot of of Siobhan's information. I want to put an SH in there. I'm sorry.
Yeah, it happens.
Miss Perry, will you be sharing the PowerPoint? Is this something?
I can share the link. Yes, I can actually put it in the chat right now.
Thank you.
Yeah.
Awesome. Well, I just want to say I learned a lot. Thank you so much. As a life insurance agent, I'm always asked a lot of the questions that were asked tonight, and I was trying to think of some other ones, and I think I got most of the ones I'm commonly asked. But I'm glad that you talked about, even if you have minor children, for beneficiary on a life insurance policy. People want their children to be their beneficiary. However, by law, a minor cannot be a beneficiary. So you're going to have to name somebody that's over 18 as the trustee or beneficiary. So thank you.
Can I interrupt you really quickly, Pam? And that's also something I would like to point out, is having a life insurance policy is such a blessing to your family. If you pass away, giving them that gift of finances. I'm not leaving you with anything, because while you're alive, you would naturally be accruing income. You would naturally be providing for your children or your spouse. So when you pass away, you have to fill that gap. And a life insurance policy is an awesome way to do that. But in addition, if you appoint a family member, a sister or brother, or a grandparent as a beneficiary because you trust them to use that money to take care of your children, that's not to say that they won't. And that's not to say that they aren't amazing, awesome, and loving people who won't take care of their children. But if something happens to them and they get into tax problems, or somebody convinces them to invest in some random business, or convinces them to marry them, or even adopt them. This is a thing where people convince older people to adopt them. The money that you've left for them to take care and raise your children is vulnerable and may not reach their children. And I don't even want to go into some of the horror stories that I've heard. So it's definitely important that you manage your life insurance policy if the goal is to take care of minor children, right? Adults is different because that's a gift that you're giving to them. But if the goal is for your life insurance policy to manage your minor children, I would definitely encourage you to create a trust to help manage that for minor children. So that's all I was going to say.
Thank you so much. And I'm just so excited that we were able to do this. And hopefully, as we move forward, maybe we'll have one that's more in depth, but definitely want to make sure that people know that you offer a free consultation. And if they reach out to you, you will get back to them. I got in contact with her. And so thank you just so much. I just really appreciate it. Madam President has her hand raised. Yes, Pam.
I just wanted to say this was an awesome financial presentation. I needed this. I definitely will be contacting Attorney Perry to, just to have a consultation and get more information. I think these are conversations that we don't like to have, but it's much needed, especially in this day and time. So kudos to you all. I mean, this was a very good and much needed presentation. Thank you so much for agreeing to do this.
Thank you so much for having me. It's really a privilege to connect with my NCCU community. Thank you.
We have a question. Are you, we have one alumni that's on, she's in DC. Are you just North Carolina, or do you work outside of North Carolina?
I can do consults with people in DC and Maryland as well, depending on what they need. If they need a bit more than what I can provide, I have referrals in both of those states. But if it's similar to the planning that I've mentioned, then more than likely I can help them.
Key has her hand raised. Key.
Yes, for the initial consultations, what's some good details or information you may need for the, starting of the initial consultation?
If you sign up for the consult, there's some screening questions, like if you're married, if you're a homeowner, if your kids, it just helps me to know what kind of plan to recommend to you. At the end of the day, I'm gonna do the plan that you want to do. So my approach is a flat fee pricing. A lot of attorneys do something called billable hours, which is they charge 200, 250, whatever their rate is per hour. But my effort to make estate planning more inclusive, especially to my communities, we work better with knowing how much it's going to cost, right? Up front. Is this a 5-hour project, a 10-hour project? So part of that was intentional in my approach to designing my packages to have flat fees. Sometimes I win and sometimes I don't win. Sometimes, I spend a lot more than what I would have spent in my billable hours on a plan. And sometimes it works out fine. But one of my pillars is making sure that my community is equipped with comprehensive estate plans. You can expect to spend anywhere from 800 to 2,000 to 3,000. It just depends on, some people want all the bells and whistles. They are in blended families. Wife wants a separate trust. Husband wants a separate trust. They have children that they didn't have together. And, so some things are more complicated than other things, but my consultations are streamlined. You will get a specific dollar amount quote at the consultation. It's not one of these things where we talk for 30 minutes and then we got to talk again. And you will leave the consultation knowing what I suggest or what you should be leaning towards, and a price that's good for about 60 days.
Great, thanks. That helps a lot. Thank you.
You're welcome.
Are there any more questions? So we did really well. We started at 6:30. It's only like 10 minutes after. So I don't want to keep anybody any longer. But, one of the conversations that Madam President Pam and I had was that, we really want to be able to support our community. And so we hope as Eagles that you will not only reach out to Savon for yourself, but refer her. That's a new campaign. That's a new challenge. Refer her to a family or friend as we build up and support Black-owned businesses. And we definitely, I'm gonna put a plug in for life insurance. So, we want to get it while we're young and healthy. Life insurance is based on health and age. I don't debate about what type. I just tell you what I offer and what other types have, and you choose what's best for you and your family. And myself is, if you want me to review a policy, if you don't understand it, I'm open to doing that, because I want to make sure that you have what you think you have in the event of a premature passing, as well as, it's just our time, right? And so just making sure that we're prepared and we're okay. One of the things Pam said, we don't like to talk about it. Well, I think we have to change our mindset and embrace talking about it, as we embrace generational wealth, as we embrace inheritance. The other thing I will say is that you can also have your alma mater as your beneficiary, right? Central has started an endowment program. And so if you find yourself where, there may not be a specific person that if you don't have any children, and well, girl, we on the same vibe. If you don't have any children, like I don't have any biological children, and so one of my thoughts is to be able to leave something to my alma mater so that it could be used for a scholarship. It could be used for that individual that needs financial aid or needs sponsorship. And so we can definitely make sure that we support North Carolina Central University and have a policy and name Central as the beneficiary. So that's all I have. And I just want to say thank y'all. I'm so excited that everybody showed up, and we're going to continue to do them. If you do have questions about anything financial, you can reach out to me. My contact information, I didn't put it in the chat, but I'm gonna just tell you, or you want me to put it in the chat? I don't know. So, because we get ready to close, you can also you can also save this chat. So again, just my name is Pam Bradford. You can contact me. My number is 919-949-8884. And you can follow me on IG as I am Cash Coach Pam. And so I really would like for us to start having conversations, and it's just planning. And like Savon said, we work hard while we're here, and let's just start having a conversation about legacy and inheritance with our family, not making it we don't want to, but we just want you to know what we're planning for you. And that's it. That's all I have. So thank everybody for coming. And if you don't have any other questions or comments, we're going to close. Savon, thank you so much again for being here, and for the wealth of knowledge you gave us. And so that's it. That's all we got, folks. So y'all have a great evening, and we'll see you at the next workshop. Thank you so much.
Thank you.
This
Good
was an
night.
awesome session. Thank you, guys.
You're welcome. Thank you so much.
Thank you.